Good evening, everybody. My name is Paul Arnell. I think I've spoken to you on one of our webinars before. I don't know if it's the same people out there. I'll be hosting today's this evening's webinar with my colleague from the law school, Carole Lyons, who's the lecturer in European law in the law school and a qualified solicitor. And we're going to discuss kind of what's happened to date in a sense, and only speculate briefly, I think, at the end of our talk on what might happen next. As you will all know, it's been a momentous few years in the United Kingdom, I guess, history, I suppose, not just the European developments, but overall history. And the UK's membership of the European Union after 47 years has come to an end. We became members firstly on the 1st of January 1973, and that is now history. So we're going to discuss why that happened and how it happened, and as I say ever so briefly at the end, what happened next. So welcome, Carole. Thank you for coming.
Thank you, Paul, for inviting me. That's good.
I guess that the first is sort of general question is, well, why did this all happen in the first place?
Why did this all happen? Okay, this of course is the longest question about Brexit, because if you have to explain very quickly about why Brexit happened, you could be here until next Christmas. But I suppose to sum it up, okay, as you said, we joined in 1973, so we've been there for 47 years. But what's interesting to note is that we did try and join twice before 73 and were refused entry, basically. So that wasn't a great start to our membership. Then to bring on a little bit further, quite often, some political scientists used to quantify the United Kingdom's membership of the EU as being that of the awkward partner. The member state which was never quite at one with the same interests as the others. So that's kind of lingered over the UK for much of its time there. And I'm not presenting our UK membership as totally negative, because it certainly wasn't, okay, far from it. But I'm just explaining the lead up to Brexit. So we had all that background. Then I think we had the watershed moment of the 1992 Maastricht Treaty, which was difficult for this country. Okay, and it was perceived to be the moment when the UK, as it were, really diverged from some other countries' view of what European integration was all about. So we can explain all of those things, but really, crunch time, the perfect storm came over the years 2014 to 2016, because the really key thing to point out, as everybody listening will realise, is that the Conservative Party, which has been in power for a large part of the 47 years we have been members, the Conservative Party has been perennially divided by the issue of membership of the European Union. It has driven the party apart. So, as I say, the perfect storm of issues against the background of everything else came in 2014, in the European Parliament elections. The party led by Mr. Nigel Farage, UKIP, gained huge numbers of seats. They were the winning party in 2014. This terrified the Conservative Party, because there was a general election due the year after. They assumed they were going to lose all their seats to UKIP. So it was the moment for Mr. David Cameron, the then Prime Minister, leader of the Conservative Party, to decide he was going to solve the Tories' problem with Europe once and for all. Okay, we know that did not end well. So he was going to solve it once and for all by, in the lead up to the 2015 general election, he promised there would be an in-out referendum on Europe. His assumption was the answer from the electorate would be, let's stay in, okay? And thereafter then, he assumed the Tories, who were not in favour of Europe, Eurosceptics, would quieten down, the Tory party would be solidified, we would still be in, and it would all be plain sailing into the sunset. As we know, exactly the opposite happened. So it's a difficult question to answer, largely, but it's a combination of factors. Yeah.
Yes, but in some sense, there's been, as you say, the UK has been apart from the EU in some senses, but also has not been a great contributor to the development and contributing, fully in the European Union institutions. And some of the, I guess, most important or as kind of important principles are resulted from UK's membership.
Absolutely. The UK has made very valuable suggestions at the time of many treaty changes, which have been taken on board. I think UK lawyers and political people were very well respected in the Brussels machine in the time we were there. Okay, so the reputation was not all negative at all.
Yes.
Yeah.
And now, I guess, just an aside, you mentioned originally was it Charles de Gaulle that was opposed to the UK's membership originally, and now it appears almost, I think, unanimously the EU member states, the remaining 27, are sad and disappointed that the UK is left. So that sort of table has turned a bit.
It has turned enormously.
I mean,
I think the EU 27, as we call the remaining states, would have been sad, to use a colloquial term, for any state to leave. Okay, but definitely the hope was that somehow, despite referendum results, the hope in Europe, I believe, genuinely, was that somehow the United Kingdom might remain. But it, as we know, it hasn't happened.
No, exactly. And that's a very long story, or a whole webinar could be on that. So we're going to have to just kind of keep moving on with the show. So there was this concern in the election in the UK Parliament, where David Cameron was elected and had made this promise prior to
hold the referendum,
and he was elected. And so then a decision was taken to leave as a result of that election.
Yes.
So how can you explain how that happened?
Well, I mean, essentially, pretty soon after the Cameron government got into power in the 2015 elections, they won quite considerably, and they weren't in coalition anymore. So it was entirely up to the Tories how they proceeded this way. They introduced a bill into Parliament very soon, the EU Referendum Act. That was supported massively in the UK Parliament, something like 550 to 50. Okay, so it got huge. Parliament was in favour of holding the referendum, and so indeed the referendum, on the basis of the Referendum Act, as passed in Parliament, was held, as we know. So that was the decision. That was what Cameron had promised. Parliament supported him. The Act was passed, and the referendum, as everybody knows, I'm sure listening, was held on that key date, 23rd of June, 2016. The result, I'm sure everybody knows it, but the result overall in the UK was for leave, 52% leave, 48% to remain. That was the UK overall, but people listening may not know how it broke down in different parts of the United Kingdom. Scotland, for example, was 62% remain. Northern Ireland was 56% remain. Wales was for leave. London was 60% remain, and various other things like that. Not that London is a separate part, but the figure was very high in London. So the referendum, basically, the Referendum Act allowed the referendum to be held. The decision was, as we've just discussed, and so the die was set. Now, a key thing to point out, of course, as everybody will realise, but to remind ourselves, was that referendum, which was authorised by the Referendum Act, that referendum was supposed to be an advisory referendum only. But as we know, the notion that the opinion of the people should only be advisory would maybe lead to action on the part of the government. That notion of advisory was lost almost the morning afterwards. Mr. Cameron resigned, eventually Mrs. May as the next Prime Minister, and we are thereafter hearing Brexit means Brexit, leave means leave.
Yes,
okay.
but the legal effect of the vote itself, I mean, or was there a legal effect in itself of the vote?
In itself was not, it did not oblige any UK government to proceed towards leave, to act.
Exactly.
Absolutely. That should be pointed out.
Exactly. Yes, but then it seems to have
the politics oversteps the law.
Morphed into some, imperative to leave, which was not the original intention of the referendum. Well,
you might say at a very cynical level, Mr. Cameron was hoping that the referendum would solve the Tory party's problems.
Yes.
Okay. Yeah. But it didn't. It exacerbated them. That's the minimal impact of the referendum. The bigger impact is, of course, it did lead eventually to us leaving. Indeed.
Yes.
Yeah.
Thank you. Just before we move on a bit, I'd pick up your point about the variation in leave versus remain, votes. And that you mentioned Scotland was at
62% remain.
And there could well be, and there has been, discussions about the consequences of that, of course, in a Scottish context, about the future of the United Kingdom,
Indeed.
and when Scotland's
Yeah.
desire, the majority of Scots who voted in referendum, and I assume that wasn't the turnout overall about 70-odd% or something.
The turnout in
more.
the UK overall was 72%, which is very, very high.
Yeah, high.
Very high for any form of voting in the UK.
A referendum, yes.
Yeah.
And I assume something similar in Scotland. I'm sorry, I don't know the numbers.
I don't know.
But clearly, a majority that voted in favor of remain in Scotland, and that's fodder to those in Scotland who who think that the Scotland is dictated to by the majority and with that.
The majority in the UK, exactly, by English and Welsh preferences.
Yeah.
And not Northern Irish and Scottish preferences. Sorry, crudely expressed.
Just a demographic fact, demographic fact, I suppose, isn't it as well?
Yes.
But that's that may well have consequences, and it's made in the news with the
Ms. Sturgeon was indeed meeting. She was giving a speech out in Brussels the other day. There have been sort of generous comments already. The former European Council President Donald Tusk saying we would be empathetic to Scottish independence coming on board. By the way, just as a little just tiny detail there, I notice from the European discourse side, so to speak, a much more generous attitude towards Scotland now than there was at the time of the 2014 referendum, because there was a lot of fear in the Brussels arena at the time of 2014 that Scotland was going to be some kind of breakaway state, and the messages were not so supportive. They have changed considerably, I would say. Categorizing them generally changed considerably since January, basically. Okay. Yes. So who knows? Because a lot of things would have to happen before Scotland would apply to become a new member state. Yes. But the messages have been positive.
Up to this point. Yeah. Okay, so we'll get back to our narrative, our big story. There was the election of David Cameron, the referendum, and then what happened next to trigger the formal process of us of the UK departing the European Union.
Well, there is, of course, as you can imagine, a formal process because, as it were, legally, everything that happens within the European Union as an entity or an organization is governed by treaties. Okay, the European Union is a product of two treaties called the Treaty on European Union, the Treaty on the Functioning of the European Union. Okay, that's detailed EU law undergraduate stuff, but it's important in response to your question because any state can only leave the European Union as authorized to do so by the treaty. And the particular provision in the treaties which allows for the mechanism of withdrawal or departure of a state to be worked out, to follow it through, is called Article 50 of the Treaty on European Union. It's a very short article. You can Google it and find it, and it really doesn't require any degree of legal training to read through it. It's fairly simply drafted. Anybody can read it, but the mechanism for leaving, the legal basis for departure, is Article 50 of the Treaty on European Union, and that governed everything really as to how the UK should proceed once it had decided to proceed after Mrs May came into power. Article 50.
And that was invoked by the UK government following the referendum.
Exactly, indeed.
And that set the whole process, the formal process of departure in motion.
Indeed. I actually have Article 50 here in front of me, but I'm not going to read it. But essentially, if I read you the very first bit, why not? Okay, very small font. Any member state may decide to withdraw from the Union in accordance with its own constitutional requirements. Very interesting. Simplistic, but very, very interesting and important terms there. So the United Kingdom effectively had to indicate, under Article 50 terms, had to indicate to the EU institutions that it was going to leave. So that was the Article 50 process. It was the mechanism for leaving.
Okay.
And had to be followed strictly.
Yes, and that was after the referendum.
Yes.
With 2016, was that when was the invocation, or is that
there lies a tale, a complex tale, because Mrs May, Brexit means Brexit, leaves mean leave, was keen to follow through the will of the people and the referendum as soon as she possibly could. She came into power as Prime Minister in July 2016. She was keen to start off this process as quickly as possible, and in her opinion, The invocation of Article 50, or the notification, or the triggering, whatever phrase you want to use, but essentially giving notice under Article 50, she assumed that that could be done by the government, okay? And it didn't have to go through the UK Parliament. She essentially thought notification under Article 50 was a function of the executive, not a function of stature of the Parliament. This, however, had repercussions, and they will be felt for a very long time in this country, because, of course, we know, all of us know, that indeed Mrs. May's government was not allowed to, as it were, secretly or without scrutiny, trigger Article 50. They were required to put the revocation, the withdrawal motion before Parliament. And they were required to do so because a case was taken, ultimately before the UK Supreme Court, by a private citizen called Gina Miller, who sought a judicial review of Mrs. May's potential decision to invoke Article 50 only using governmental powers, executive powers, okay? And the Supreme Court supported, not unanimously actually, if I remember rightly, supported Mrs. Miller, and indeed stated that notification under Article 50 was a function for Parliament to scrutinise and was not something that would be correctly done by the executive. So that was an important legal complication that arose from Article 50. That was the first Miller case.
Yes.
Yeah.
And so there's been a 2 or 3 years in the interim. Just now, I guess maybe get the time scale between the formal invitation and then last month there's been 3 years.
It's been, I can tell you, of the Miller case, although it was held very rapidly, what we've seen, funnily enough, for any lawyers listening, what we've seen, funnily enough, from the whole Brexit process in this country, which of course has been constitutionally cataclysmic, really, but we have seen, very interestingly, how quickly our courts, both in London and Scotland in particular, and indeed in Belfast, but how our courts can act quickly when they have to, and they have been called upon to do so on many an occasion over the last few years. So the Miller case came about expedited quickly. The decision, I believe, was, the case was heard in December 2016. The judgment came out early January 2017, and thereafter then Mrs. May had to go to Parliament, get another act passed to authorise the withdrawal being notified under Article 50. Again, all being done very quickly. So I can tell you that ultimately, Mrs. May, on behalf of the UK, head of government obviously, having been authorised to do so by Parliament, notified the President of the European Council on the 29th of March 2017 that we were leaving. Okay? That date was crucial because careful reading of Article 50 TEU will tell you that thereafter we only had 2 years, really, okay, at some level, we only had 2 years to negotiate our withdrawal, okay, because that is the terminology of Article 50.
Okay, so that's sort of starting
exactly.
one process, and I guess there was, just like maybe some of our students, sometimes there was deadlines and extensions and extensions and deadlines.
Indeed.
Never set in absolute stone. But setting that process, and now just almost 3 years later, finally just on last January, just a couple of weeks ago,
a few days ago,
was the day that the UK left.
And by the way, having had in the interim 3 extensions of that 2-year period, because we all know we should have left on 29th of March 2019, but on 3 occasions the United Kingdom requested an extension to its negotiation of withdrawal period, as is allowed by Article 50 on 3 occasions. The last extremely reluctantly, because Mr. Johnson was by then Prime Minister, and he had said famously, infamously, that he would, I believe, he said he would die in a ditch before his government would request another extension under Article 50. That's all history now. Yes. Ancient history. It's only last October, but it's already ancient history. We did request a final 3rd extension. It was granted, and the deadline given in that one was the 31st of January 2020. And we have now left on the basis of that.
We're left past it. Okay, well, thank you. That you've already addressed one of the cases that I wanted maybe we could briefly mention. It was after the, I don't know if I'm using invocation the right term, but after the notice was given, there was a whole series of complications in UK law, I guess almost exclusively, I suppose. I don't know if there was any complications in the European institutions, but in the UK constitutionally was a big challenge in many ways, I think, for this unprecedented procedure of being part of this organization. Very important legal consequences and the legal relationship. And so if uncharted waters, and with the government, and correct me if I'm wrong, appears to be dead keen and perhaps paying less heed to some constitutional niceties should have.
Indeed,
is a way.
Maybe less keen to follow them. Indeed, as time progressed, you might say.
So I wonder if you could just highlight. I know there's been a number in a very complicated story, but a couple of the highlight of the cases that are. The famous one with Lady Hale giving judgment, and there's another one as well. You can tell us
absolutely.
about that.
But I will pick you up actually on one important point you make there about it being uncharted waters here constitutionally. It also, of course, was for Europe generally, for the EU generally, uncharted waters, because in case anybody doesn't realize, Article 50 process is entirely, well, it's quite new. It's only been in the treaties, only been a legal basis in the treaties since 2007, so since the Lisbon Treaty changes. And of course, needs to say, the United Kingdom is the first state which has used it. So they were uncharted waters generally about how all this withdrawal should work. But coming back to the UK and its particular constitutional paroxysms we got into as a result of the notification of the withdrawal. So we had the Miller 1 case, which was all about government versus parliament, who gets to invoke trigger Article 50. Then the next really important case that we saw in this arena was a very interesting case which took place largely in the Scottish courts. It did hit the Supreme Court, and it also, importantly, of course, hit the European Court of Justice. But it was started in Scotland, largely by Scottish politicians, supported by an English barrister, QC, called Jolyon Maugham. And this case is the very important case called the Whiteman case, after the name of Mr. Andy Whiteman, who's a Green Party MSP. There was a coalition, a rainbow coalition of various people from different parties who took the Whiteman case. Now, why were these people gathering together to bring a case in the Scottish courts? They were doing so because they were seeking an answer to one of the issues which was not contained in Article 50. Namely, if a state does trigger Article 50 and tells the EU it wishes to leave, can it effectively change its mind? Okay, and this was represented, and indeed, I absolutely agree, it was a very significant thing that parliamentarians would need to know, or people generally would need to know, because we need to know fully what the options were for the UK once Article 50 had been notified. And it wasn't answered. It simply wasn't answered in Article 50. So the case went through various levels of Scottish courts, okay, a lot of acrimony, a lot of, indeed, speedily going through the Scottish courts. There was an attempted appeal down to the Supreme Court to try and stop the case going any further to Europe. The Supreme Court said no. So effectively, to sum up what happened in Whiteman, the issue of whether a state can change its mind was referred from the Court of Session in our house to the Court of Justice of the European Union in November 2018. This is all happening as lots of other things are going on at the same time, of course, politically, and in a really significant judgment. The judges in the Court of Justice of the European Union decided that indeed a state can, of course, change its mind, okay, once it has decided to leave, because ultimately, and this is the importance of the Whiteman decision really, ultimately they said states maintain their sovereignty even in these matters, like withdrawal, even though they are members of the member states of the European Union. So that was the Whiteman case. That's so effectively, if you want to think Whiteman, it's about a state changing its mind.
So there was a possibility of going back, and
it
never happened, obviously, but it was in law possible.
Absolutely. In law, it was deemed to be possible. Okay, an interpretation of Article 50 by the EU judges was this is possible. The next really important case concerns the fact that when Mr. Johnson became Prime Minister, which I believe he did in about July 2019, one of the things Mr. Johnson did, I think, in early September 2019, was to prorogue Parliament. Okay, that means essentially to suspend the operation of Parliament. He decided that Parliament effectively should be suspended, shut down effectively for 5 weeks. There were various reasons put forward by the government for suspending, but I think it was generally felt, it was widely felt that this was being an attempt to somehow sort of stymie, indeed to use a Scottish court's words, stymie the whole Brexit process. Okay, so this proroguing by the Prime Minister, the government effectively, had two judicial consequences, because a case was taken in the Scottish courts and a case was started down in the English courts. The case in Scotland began first, which is why I refer to this case as the Cherry Miller case, because Joanna Cherry, along with Julian Maugham again, were the litigants in the Scottish side of this, and Gina Miller, once again, same person as in 2017, was the primary litigant in the English case. But they all had exactly the same point. They wanted effectively an assessment, a judicial assessment of the validity or otherwise of the proroguing of Parliament by the British government, by the UK government. Okay, and both cases, Cherry and Miller, joined together in the Supreme Court in when would that have been? I think it was, would have been September 2019. Again, held very, very quickly. And it was decided this time unanimously in Cherry Miller, number 2, that the proroguing of Parliament was null and void. Okay? And so Parliament was recalled.
Yes.
So that had it's Brexit law behind it, but that was about the constitutional matters. Okay?
Yes, having an interesting constitutional law myself. I mean, and just the whole process, obviously. I mean, an iconic moment in UK constitutional history.
It was Lady Hale's judgment, of course. She was president of the Supreme Court, and unanimously. Well, the first time I think the Supreme Court since it was set up has been unanimous. Okay, 11 justices there. Exactly. It really is an iconic constitutional law case. Okay?
I don't know the stats
generated by Brexit, but
I wonder how many members of the public would have been watching that, or probably quite an all-time record for people taking such an interest in constitutional matters. I would have thought. I don't know. I'm just talking off the top of my head.
I think there were a lot of people. Numbers. If there's an upside, a silver lining to the whole of Brexit, I think it has generated a massive level of interest in constitutional law in this country.
Yes.
So there's a...
Yes, I have to say, there's a negative side to that, I'm afraid. There's some government statements to think that the justices of the Supreme Court and other judges have gone too far.
Well, absolutely.
And overstepped the mark. And so there hopefully will not be a backlash
there may well be. There may well be. Okay.
That's a different question. But,
that's an entirely different question. But indeed, it may indeed have exactly the consequences that you're suggesting. Okay, because of course the government was clearly not pleased at being exposed as having done something that was fundamentally declared null and void.
Yes.
In Cherry Miller too. Yeah.
Okay, but fascinating about litigation. Yeah. So then, but eventually, all of that was I guess, overcome from the government's point of view in one way or other. Yeah. And we've had finally, after Johnson's election, the conclusion of withdrawal agreement.
Absolutely.
I wonder if you can tell us a little bit about how that happened and what it does.
Well, I'm holding here, not I should add for any good EU lawyers looking at me, this is the first version of the withdrawal agreement, okay? Because there have been 2 versions. So just explain how that worked out. You can see it's very large, 600 pages, okay? So that's the first version. Theresa May, once she became Prime Minister, obviously negotiated on the basis of Article 50 terms what in simplistic vernacular we would call the divorce agreement with the EU. It was obvious we were leaving, or almost leaving. So an agreement had to be signed between the 2 parties how that leaving would actually be function, okay? And that is simply what the withdrawal agreement does. All it does, all 600 pages really, boils down to one thing is it basically sets out the terms of the divorce. That's what it does, okay? Mrs. May had one version of it which was rejected 3 times in Parliament. When Mr. Johnson became Prime Minister, he was able to, okay, we won't go into the whys and wherefore of it. He was obviously against this agreement while he was not Prime Minister, but once he came back into power, his government began a renegotiation of the deal, okay, with the European Union, because there are two sides here, the UK and the European Union, and then he emerged gloriously with what he called a new deal. But let's be frank here, the new version of the withdrawal agreement, which is still just as long, was largely unchanged from Mrs. May's thrice rejected one, except insofar as, largely speaking, the part of the withdrawal agreement which deals with Northern Ireland. Okay, so Mr. Johnson, there's a political dimension to this too, because you might remember, of course you will, Paul, that Mrs. May was in a minority government. She was dependent upon support of the Democratic Unionist Party in Northern Ireland. So she had that as part of how she was functioning. Okay, Mr. Johnson, although by then he hadn't won his massive landslide, okay, Mr. Johnson was, should we say, a little bit more willing to not see himself shackled by Northern Irish preferences, and he was able to renegotiate the part of the withdrawal agreement that dealt with Northern Ireland. And so, lo and behold, okay, the fourth time the withdrawal agreement was presented before Parliament, it was actually accepted. Okay, so accepted. In law, it's a treaty. It has to be ratified by the two parties, that is, namely, the United Kingdom Parliament and the EU institutions, Parliament and Council, and all those processes have now taken place right up to the wire. Okay, the European Parliament ratified it on the 29th January, just a few weeks ago, and the Council of the European Union accepted it on the 30th. We left on the 31st. The UK Parliament ratified it on the 23rd of January. So all, it's been ratified and accepted. The divorce was finalised literally right up to the wire. So it's now been, the divorce agreement is now in place.
Okay, well, thank you. That clarifies quite a bit, but that's an important for us, I think, and generally speaking, though, is, so this is a divorce, the agreement, including payment from the UK to the EU, and indeed we'll mention the transition period. All of these things are part of this 600-page deal, but absent is any provision on what happens in the future. Isn't that right? So this is not, I mean, Brexit is not done, if I could use that word or something in a sense.
Contrary to your Prime Minister, who did say just about last week that Brexit was done. So that has been stated at governmental level, but I'm sorry to say I would disagree with that. Brexit is definitely not done, okay? Because the withdrawal agreement, again to resort to very simplistic terminology, is just the divorce agreement. We've still got to decide with who's going to deal with the kids, how the house is going to be divided, etc. In short, what that means is the future relationship, which is the key thing. Okay. In other words, all the rules and regulations about how our trade is going to function in the future with the EU, our fisheries, to a certain extent, some level, citizenship rights, details of that, mostly trade, of course, is a big deal. Okay. All of those things still have to be determined.
Yes.
And the time is against us hugely, because the withdrawal agreement, as passed just 10 days ago, the withdrawal agreement provides for a transition period in order specifically to negotiate the future relationship. Now, the withdrawal agreement allows for the transition period to be longer than it currently is. It currently is stated to end on the 31st of December 2020, which gives us roughly 10 months, okay, give or take, okay. The withdrawal agreement allows for, if the UK wishes to, okay, it could get a 2-year extension on that. So we could potentially have not 1 year, but 3, okay, extended until the end of 2022, okay. But again, Mr. Johnson's government has indicated it will not seek an extension to transition. So what we are now in is a position where we are now facing the negotiation of vital future relationship documents to determine really what's going to happen to the UK in the future as from 1 January next year. Yes. And already, as people know, following the press, following the media, etc., we all know that there are some issues already hitting the headlines massively. The issue of whether there will be customs checks is a huge one for all of us individually as to the price of the food we will eat, okay, and the availability of same. For farmers, fisheries is a huge issue because, of course, part of the taking back control of Brexit was taking back control of our fisheries. Looks like that's not going to happen because fisheries is going to be possibly, renegotiated in favour of financial arrangements, and so on and so forth. Gibraltar, I would mention too. So in short, the future relationship is going to be hugely important, and we to a large extent, we don't know what's going to happen. The EU helpfully have produced a document just last week, 33-page document indicating their negotiation stance. The European Parliament discussed it just yesterday. I've got the documents here, okay? So the EU institutions are acting already very rapidly on how they are going to negotiate the future relationship. What we had from the UK side so far was a little written statement to Parliament, which is produced on the Parliament website, and I think maybe there was a speech from Mr. Johnson last week, but there was not substantive detail in either of those things. So that's where we are at really at the moment. Okay.
I mean, that's in a way it's really quite surprising and maybe shocking, if that's not too strong a word, that the most important thing must be, if the UK leaves, is to have a settled, I guess fair but settled relationship with our closest and biggest trading partners.
Indeed.
And indeed, from my own perspective, I come from a sort of criminal cooperation point of view. We have our biggest business with our European neighbors in extradition and evidence cooperation and DNA and advanced passenger information. All of these criminal, that's the criminal sphere only, a small part of the overall. But clearly, this withdrawal agreement, as big as it is in historical terms perhaps a footnote.
Oh, it's an absolute footnote. It may have taken us 3.5 years, nearly 4, to sort the thing out. But the agreement is, I mean, in that respect, I do agree with Mr. Johnson. This is history. The withdrawal agreement will serve us until the end of this year. But the much more important is all the fine detail of effectively the untangling and rebuilding of all the interconnections and relationships we had with our European partners for 47 years and 30 days. That's going to be the difficult dimension.
And
time is really against us here.
And so the rest is going to be far from history. It's going to be on I think the front story of the newspapers or the television almost for the next 10 or 11 months.
At the very least, Paul, at the very least. Because we face genuinely another sort of cliffhanger moment on 31st of December this year, if all the sufficient deals, trade deals, etc., have not been agreed by that time. So we're up in the air, and I guess this is. I mean, as I started our webinar tonight, I mean, what's next? And we know what's next. I guess intense negotiations once the is in a position to start. I don't think even have they. The formal negotiations haven't started? Formal negotiations haven't started. No. The EU institutions are working through the setting up of their starting it. So it's been through Commission now to Parliament. Okay, so they are setting in place their legal basis for negotiation. The United Kingdom hasn't, as much as we know, hasn't started formally any form of preparation for negotiation yet, as far as we know.
So there's really no way that we could, with any degree of certainty, speculate one way or on the other. I suppose there's been statements from both sides.
Statements from both sides. Statement from Mr. Gove the other day about we won't have frictionless trade. We're just reliant on that at this stage. Okay.
But perhaps is that a matter of negotiation stances? Take a hard line first and come to the middle, or we don't know. I suppose
we don't know. I mean, I'm not a trade lawyer. Okay, you can read many eminent trade experts out there on the Twitter sphere who know much more about this, but trade negotiations are incredibly complex processes. They're partly political, they're partly detailed legal substance, they're a combination of it all. Very, very time consuming, okay? And bizarrely, for what we're unraveling the already established relationships rather than going towards something, as it were, positive in the future. So
unraveling them only to try to rebuild them again
indeed,
to some,
a different
some
format. Yes, exactly.
Way or other,
exactly.
Maybe into what extent whether the Court of Justice of the EU will have any hand in it at all.
Precisely.
In other matters. Okay. I mean, just about the length of time. I know we're just about finished, and if you don't mind me referring to my area for a second, I know that Iceland and Norway have recently concluded an agreement with the European Union on a similar form of European arrest warrant. Which took about 9 or 10 years to enter into force once conclusion, and they are a member of the Schengen.
Of course, already.
Yes, and so this even that length of time with such similar countries for Well, is an indication perhaps of
thank you for that detail. Absolutely.
difficult it
would
might
be
be.
the observation of most people who are experts in their field, looking on the impossibility of realistically in 4 to 6 months, okay, of producing the kind of things you're talking about, Paul, in all the realms in which we have to unravel and rebuild.
Okay,
yeah,
so in many stages, in many senses, I suppose, we're kind of at stage one, really, in a sense, stage one of the future, I suppose.
It's fair to call it phase 2 because the last 4 tortuous years are nearly behind us, but this phase 2 is going to be much more important, substantively, than the withdrawal agreement and everything else that went
for the
before.
for the country
Absolutely.
and for the country's children and our future and well-being
much more
and
important,
the economy and everything. So.
Absolutely.